All right, well, good morning, drivers, and welcome to Inside Trucking, Episode 7, the SBTC complaint to FMCSA against TQL, Total Quality Logistics, seeking broker license interruption, transparency and accountability and enforcement. Oh my. So that's today's program. Before we get into that, though, let me start with a little background and first I want to say, usually I do these shows, these programs in the afternoon, and it's morning right now, and kind of getting influenced, I guess you would say, by that guy on Facebook, Robert Dennis Murphy, the guy that does Morning Coffee with Bob. So he's talking about broker transparency over the last day or so. So go and check out his lives that he does on Facebook, and that guy knows what he's talking about. So he's talking about 40%, with the TQL Pink Cheetah load of ice cream from 2023. So people are starting to see what's really going on here. And, Bob says, until you show me the evidence, I've seen the evidence on one load and brokers are taking 40%, big brokers, and he says, so as far as I'm concerned, everybody's taking 40%. And Bob, you might be right. I have no evidence to the contrary to offer at the moment. So check out Morning Coffee with Bob every once in a while. Great guy, Robert Dennis Murphy. In addition, I also want to make note and mention at the onset here that our friends Chris and Michael and all those guys over at Past Time for a Change have put up a petition as of today, so you can sign on to our complaint against FMCSA, at least in theory, right? You can give us some moral support. They have a petition going up today, and it's all about this complaint that I'm going to tell you about today. So with that said, let's get into it and let's talk about the complaint. What we're going to do here today is we're going to explain the latest developments in this ongoing TQL broker transparency saga. This has been like a 5.5-year battle for us at SBTC since we first filed the petition, the first petition for rulemaking back on May 6th of 2020 in the middle of COVID. We asked FMCSA to please look at this waiver nonsense that these big brokers do with respect to broker transparency rule 371.3. Stop the waivers, compel compliance, enforce the law. So it's been 5.5 years since we've been trying to strengthen transparency. We consider it an ongoing quest to strengthen and enforce 49 CFR 371.3 and outlaw these contractual waivers that brokers use to unlawfully deregulate themselves, evade regulation, in our opinion, in violation of federal law, and we think possibly, this may entail unreasonable restraint of trade in violation of the Sherman Antitrust Act, and there could be RICO implications here. This is serious stuff, folks, and so you really need to watch what's going on. This complaint is, as it says in the title, all about a request for FMCSA to interrupt TQL's broker license. Now, you can say suspend, revoke, interrupt, but that's what we're going to talk about today. So let me kind of suggest, this goes back even before that May 6th petition for rulemaking. We actually filed a complaint with the U.S. Department of Justice in April of 2020. That was kind of like the first step It was an antitrust complaint. It's all about, you know, this nonsense of waiving contracts and we think unreasonably restraining trade. So, you know, that came first, and then you saw those guys go to the White House after that complaint, starting on May 1st, May Day of 2020. And as that was going on for the next, 21 days, I think it was, that's when we filed that May 6th, 2020 petition for rulemaking. And, you know, it's gone down the pike. And, you know, if you look at the petition that these guys just put up on Past Time for a Change, there's a really good timeline, you know, a background timeline that you'll see. But, of course, you know, the most important thing, other than the first petition, which OIDA then followed and other people got on the bandwagon, is, of course, this rulemaking that finally came out in November of 2024. And it got 7,000 comments, just under 7,000 comments over the course of 2 rulemaking periods. The rulemaking opened in November, it closed in January. Some of the guys from NOAA, including Mike Boston, came to us and they said, hey, you know, maybe we should try to get some more time to extend the rulemaking just as it was about to close. And we said, you know, Mike, that's a great idea. And so we did that, and as a petitioner, and we asked Larry Miner at FMCSA to please extend it. And he said, well, it's kind of too late to extend, but we could reopen if you want. And so they did that. And so there was a second comment period earlier this year, and so the total number of comments essentially is just under 7,000. And so now, as of September of 2025, when that spring unified agenda finally came out in September, they said that they're scrapping the rulemaking and they're going to start over. And don't get me started on starting over, because we know where that comes from. That's SBA's recommendation, SBA Office of Advocacy, after they talked to all the small brokers at the Transportation Intermediaries Association. Like, those guys represent small brokers. Come on, give me a break. I got a bridge in Brooklyn to sell you if you believe that one, all right? Those guys represent TQL and C.H. Robinson and all the big brokers. Maybe they have some small brokers, but come on. You know, they're pushing for the agenda of big 3PLs. So that's kind of like the, you know, the main background that goes with this. So what we've done now is, as of September 29th of 2025, SBTC has filed a complaint with FMCSA. We've had enough, because we've been hearing about, you know, these waivers for years. We've been hearing about, you know, non-compliance with 371.3 among many big brokers for years, but TQL seems to be, based on our contacts from our members and other followers in the industry, it seems to be the prime offender. And so we watched, you know, all of that drama play out with Pink Cheetah Express, right? Dakota Springfields and TQL. And, you know, we saw that she lost her case in September. The judge threw it out in response to motion to dismiss by TQL. But the judge was not happy with TQL. And I think TQL knows that. I think a lot of Freight X guys know that. Nobody's talking about this, right? That's why we're going to do this show today. So, you know, we see that it was kind of like, I really don't want to throw this out. Judge Sparkle said, I don't like this nonsense that's going on, but, you know, I'm gonna have to throw it out. And so now it's under appeal. So it ain't over. So, you know, if this is like a Star Wars saga, you know, the Pink Cheetah Strikes Back, right? So watch. I did a whole show on Pink Cheetah, you know, a couple of weeks ago. So, you know, go find that one on the channel, Inside Trucking here, and you'll learn more about that. So I don't want to repeat all that stuff, you know, but let me tell you about this particular action that we have taken. So September 29th, 2025, we wrote to Secretary Duffy, and we lodged a formal complaint. And and the complaint is pursuant to a section of the federal code, the actual, United States Code, federal statutes, and actually it references another code. So it's pursuant to 49 USC 14701B, and it references 49 U.S. Code 13905. And let me tell you what these laws say, so you understand. So 14701A under Title 49 says investigations. I'm going to read this to you. The Secretary or the Board, that means the Surface Transportation Board. So the Secretary of Transportation or the Surface Transportation Board, as applicable, may begin an investigation under this part under this part on the Secretary or the Board's own initiative. So they can just start an investigation themselves, or on complaint. That's what this is. This is a complaint. If the Secretary or Board, as applicable, finds that a carrier or broker is violating this part, the Secretary or Board, as applicable, shall, and that's a duty, shall take appropriate action to compel compliance with this part. So if somebody complains and they say, yeah, it looks like there's a violation, then they shall compel compliance, right? That's what the federal law says. That's the duty that Secretary Duffy is under. Now, SBTC, right? We're a nonprofit organization, a trade association, and we're a corporation, and we have 21,000 members, and so we qualify as, quote, a person, right? A corporation is a person, and we have standing because our members, we have what's called associational standing, because our members have been affected by this situation, and so we have the right to complain on behalf of our members. That's associational standing. And so we're suggesting that our members, including one of our members, Pink Cheetah Express, who happens to be, with respect to the owner, Dakota Springfield, happens to be a board member of the SBTC, right? Well, she's on the board of directors. Our members have been injured, in our opinion, by Total Quality Logistics through what we believe is TQL's chronic abusive pattern and practice of violations of 49 CFR 371.3. And we contend the evasion of regulation law, right? So there's the regulations, and then there's the law, right? And that is a law, 49 USC 14906. Go Google that one. And of course, we're also contending that there's possibly unreasonable restraint of trade under the Sherman Antitrust Act going on here, thus our April 2020 antitrust complaint, right, which is not the first time that we filed one of those complaints. And it may even give rise to a civil RICO action, right? A RICO, Racketeer Influenced Corrupt Organization Act is what RICO stands for. And we are suggesting that somebody should look at this from the perspective of RICO. RICO has both criminal and civil implications. So depending on who's bringing a RICO action, it could either be criminal, like the Attorney General, FBI, and all those guys on the criminal side, or any person or any group of persons through a class action, trade association, etc., can bring the civil type of action. So we're saying there's some kind of basis here, we think, for somebody to look at RICO here, because TQL, as we understand it, regularly relies on contractual waivers of 49 CFR 371.3, and then does not comply with 371.3 transportation transparency requests on the basis of those contractual waivers, despite the fact that we now all know that on November 30th, 2023, TQL was served with, I don't know what you want to call it, instructions, directive, order, as Pink Cheetah calls it. I don't think it's guidance, as the judge and TQL talk about, because it's instructions to comply, right? It's not, hey, I'd like to give you guidance and give you some friendly advice. US DOT gives you a directive and says, take those waivers out of your contracts and comply moving forward, because I already found a violation and made you give one contract to Pink Cheetah, and now as a wrap up to that investigation, I'm gonna tell you don't do it again, right? So it's not that you didn't do it, just don't do it again. So okay, so we think there's a whole bunch of different things here. Now there's also a mechanism in this U.S. Code 14701 in paragraph B that establishes, a mechanism for persons to file complaints against registered brokers like TQL. And it states, B, complaints. A person, including a governmental authority, may file with the secretary or board as applicable a complaint about a violation of this part by a carrier or broker providing transportation or service subject to jurisdiction under this part. The complaint must state the facts that are the subject of the violation. The secretary or board as applicable may dismiss a complaint that it determines does not reasonably state grounds for investigation and action. So we know that that's what the law says here. So we have composed a complaint which defines us as a person and which states the facts that are the subject of the violation, willful noncompliance with 371.3 over a chronic period of time. And we believe we've reasonably stated the grounds for requesting an investigation and for the secretary to take action, which he shall do if he finds there's a violation under the law, duty of the secretary. Now, here's the interesting statute. 49 USC 13905 says what the secretary can do if he finds a violation of the regulations, and it's at the level of willful noncompliance, or there's other language here you'll see in just a second, right? So subsection D of that particular statute, suspension, amendments, and revocations, right? Oh my. Complaints and actions on the secretary's own initiative, on complaint, that's what this is, or on the secretary's own initiative, and after notice and an opportunity for a proceeding. So they have to start a proceeding, right? What's a proceeding? Well, it's a governmental, hearing into a matter such as, allegations in a complaint. So it says the secretary may suspend, amend, or revoke any part of the registration of a motor carrier or broker for willful failure to comply. That's the buzzwords there, right? That's the phrase. Remember that. Willful failure to comply with this part, or an applicable regulation or order of the secretary or the board, Surface Transportation Board, right? Now, here's the distinction. With respect to the Pink Cheetah case, where she's trying to get TQL to be told they must comply with the directive of the secretary, which she says is an order, we agree with her, because it meets the definition of order in the Administrative Procedure Act, not the dictionary, right? The Administrative Procedure Act, that's what matters. Despite that whole fight over whether that email from Nelson Newcomb on November 30th, 2023 was or was not an order, here it doesn't matter, because here the language is an applicable regulation or order of the secretary. Okay, we won't even have to get to whether that email was an order for the purpose of this complaint, because it's either order or regulation. So we'll go right to regulation. And we'll say, Secretary Duffy, and hope you're watching here, and my friends at FMCSA, the new FMCSA, and Derek Bars and Jesse Ellison and all those guys, right? I hope you're watching, because when it comes to this complaint that SBTC filed on September 29, 2025 with the Secretary, ergo with FMCSA, what matters is whether you make a finding that TQL is in some sort of willful failure to comply realm with a regulation. You want to call that an order as well? Fine, but we don't even need to get that far, right? So 371.3 is a regulation. Willful failure to comply with 371.3. So we have therefore established reasonable grounds for investigation and action. We've told the Secretary what that action is, right? You can suspend or revoke TQL's license, and we have requested a formal investigative proceeding and are suggesting that we are entitled as relief to our complaint under 49 U.S. Code 13905. We are entitled to an order from the Secretary, right, revoking or suspending TQL's license until such time as it gets with the program and conforms and complies with FMCSA regulations, including but not limited to 49 CFR 371.3. Now, Secretary Duffy just did this. He just did this with a series of non-conformity letters, notices of non-conformity to 3 states on the English language proficiency issue, right? So, this is nothing new. You can go ahead and you can, send TQL a, notice of non-conformity, give them a chance to comply one last time, and that means take all the waivers out of their contracts, waivers of 371.3 broker transparency rights, and prove it, to the Secretary. Otherwise, you should face, just like the states are facing loss of funding, and if we have our way, RICO investigation on them, like California and New York, just like they're facing, the loss of funding, TQL should be facing the loss of his license. Now, whether that's a suspension level or a revocation level, we're not really concerned about that, right? We just want them to be paused until such time as they can comply, and maybe they're not going to comply, and then maybe revocation is appropriate. Maybe they lose their license. This is a 12, or I should say, I think it's $11 billion a year business. So look, we're not asking to put them out of business, because that's not reasonable, and quite frankly, that probably would have an effect on the supply chain and payments to the carriers and all that kind of stuff. So we're asking for a timeout, really. And if they still are not willing to comply, maybe they could be revoked. But we'll leave that, to the powers that be, and that's a matter of what the Secretary and the governmental authorities think is just and proper in response to this complaint. But they need to do something. They need to at least, suspend their license and get their attention, because nothing gets their attention, and this even went before a judge, and even that didn't get their attention. They just don't want to tell you what percentage commission they're really keeping. They just don't want to tell you. And why? Why are they fighting tooth and nail? Why didn't they give Dakota Springfields the other 14 loads after they were made to give her one, after they were forced to comply by Nelson Newcomb on that first load, January 2023 load of ice cream that showed almost 40%, just under 40%, 39.5 or something like that, that they kept? Is it because that's their regular routine? Is that their regular course of business, that those loads would all show 40% also, or in that realm? Is the problem that it's above what broker industry has determined is a reasonable and customary commission or margin, as they like to say? What is that? 12.5% to 16%, depending on when and who you ask. Voltman in 2020, 16% average margins, he said, brokers take. And then now Ken Adamo at DAT, the last I heard, was 12.5%. Is the problem that when the records come out, you do the math and you determine how much your broker took, like TQL? Is the problem it's all going to show beyond what's reasonable and customary? It's above 16%? It's in the 35, 40, maybe even more range? Ask Bob. Bob, how much do brokers take? 40%, right? Until and unless we're shown otherwise, right? So let me just read two last things to you, and then I'll wish you a pleasant afternoon or a pleasant day. In the rulemaking that's now been paused, right? Because they're going to do new second rulemaking in May of 2026, and we don't know why. We don't know what that's going to entail. We don't know if they're diluting the first rulemaking, negotiated rulemaking, as SBA Office of Advocacy suggested on behalf of the small freight brokers, right, at TQL and TIA. We don't know if they're going to strengthen it. We're not sure now. Derek Bars, is in power at FMCSA. We're not sure what influence he's going to have. Derek, remember, Senate confirmation hearing, I promise accountability and transparency, right? And we'll add enforcement, oh my, right? But let me read to you what FMCSA said, and they kind of in that November 2024 notice of proposed rulemaking, they kind of went back and forth. They flip-flopped. They didn't give us what we asked for, which is no waivers. They didn't give OIDA what they asked for 13 days later, which is also no waivers. They gave a couple of things like 48 hours electronic release upon request. But the issues here are you got to stop them from waiving the regulations and deregulating themselves and evading regulation, and you got to make it so that it's automatic, that release of records. Otherwise, we all know there's blacklisting, and the whole thing is just one big joke. Don't you dare ask. If you ask, I'll give it to you within 48 hours, but don't you ask, I'll never give you another load again, right? And quite frankly, once you get the records, you may never take a load again. Transparency is not about what you made or did not make on your last load. It's about what you're going to make or not make on your next load. That's the purpose of transparency. Nobody says you can undo a contract and undo the numbers on your last load, but you sure can use that to your advantage to think about who you want to do business with and ultimately what rates you're being shown under the guise of, brokers are only taking 12.5%, whether that's really a rate that you should accept or whether you should negotiate harder or whether you should walk away. So let's take a look at this. In the November 2024 rulemaking, FMCSA, as they go back and forth, they do say one important thing that we want to point out, and we hope they say it again in the next notice of proposed rulemaking in May of 2026, and that is they quoted a court case, and that court case is known as Taylor Energy Company versus United States. And here's what FMCSA says and quotes from the case, right? FMCSA said, a regulated entity must adhere to the regulations and cannot, now quoting from the case, disguise its regulatory obligations as contractual ones. End quote, end quote. Right? So FMCSA is saying, you really, you're not supposed to do this, and what we're going to do is we're going to change the rule as of November of 2024 draft. They said we're going to change the rules so that it's not so much about 371.3 and broker transparency is a carrier's right. We're going to make it a duty of a broker. And then they offer this quote. And again, Secretary Duffy, we remind you that you have a duty once you get this complaint from us. If you determine that there's a violation, and we can't imagine how you wouldn't, because you already did. Nelson Newcomb already did. He already compelled compliance back in October of 2023, and then in November of 2023, he issued a directive that said, don't do this again. Don't deny a carrier their 371.3 rights and stop using these waivers. They are hereby disallowed, essentially, is what that says. The last thing I'm going to point out is, in this case, broker transparency lawsuit, right? Pink Cheetah Express versus TQL. The judge approved the motion to dismiss, and the case ended. Though it's not over yet because there's an appeal. It's in progress. So, hold on. But as the judge dismissed the case, it's evident that she dismissed the case reluctantly. She did not want to dismiss the case. She did as what she thought was a matter of law, and I think she's wrong on that, with all due respect, and I think that's going to be, the nature of the appeal, that she erred as a matter of law, but we'll wait for Pink Cheetah to speak out about that. But she's disturbed by what's going on here. And so what she says in a footnote at the end of the decision is she says, quote, "It troubles the court that regulated entities may attempt to evade regulatory obligations by embedding waivers in contracts." End quote. And that is so important. I'm going to read it one more time. It troubles the court that regulated entities may attempt to evade regulatory obligations by embedding waivers in contracts. And so what she's saying there, she's troubled. She's saying that there appears to be evasion of regulation going on here, and it has to do with putting waivers in contracts. So this is not over either at the judicial level or the regulatory level in terms of upcoming rulemaking, but now there's a complaint that the SBTC has filed, and now we have stated the Secretary of Transportation has the power to suspend or revoke a broker's license under 49 U.S.C. 13905 for willful failure to comply with an applicable regulation of the Secretary. That's what this is, 371.3. And accordingly, we hereby request you please open a proceeding to revoke or suspend TQL's broker license for arrogantly, willfully, and chronically failing to comply with 49 CFR 371.3. So there you have it, folks. It doesn't have to be an order. We don't have to, worry about what is an order, what is guidance, and all that kind of stuff. We'll let the courts, handle that. But for the purpose of this complaint and the Secretary's duty to take action if the Secretary determines that there's evidence of a violation, we have the right to seek, and Secretary Duffy has the duty to issue an order to rectify this, and we think that it should be an order suspending the license, because that's the only thing that is going to get through to those guys over at TQL. So hopefully, we will see some action on this complaint. And like I said at the beginning, you now can sign on to this complaint if you think that we're right. If you think that you want to step up and say, yeah, I believe in that complaint, and I think their license should be suspended or revoked too. Go to Past Time for a Change and sign the petition and get get your name out there and be heard, because none of this works unless all of you guys get together. You did when it came to filing complaint or filing comments, right? 7,000 of them, and we're going to have to go through it again, it looks like. But now you can also hurry this up, and let's get the attention of the secretary through this petition. So please sign on Pastime for Change, the petition to suspend or revoke TQL's broker license. That's all for today, folks. I hope you have a great day. And I'm James Lamb, and this is Inside Trucking. And I look forward to speaking with you again. Take care. Bye-bye now.